The court just rewrote the rulebook. 12 new laws. One historic decision. And if you own, carry, or even believe in the right to protect yourself, what just happened in Washington changes everything. This isn't theory. This isn't politics. This is your freedom under review. A 6-3 ruling just detonated across the nation. It tore through decades of state restrictions, rewired what lawful carry even means, and redrew the lines of what the Second Amendment stands for in 2025. If you think this won't reach your state, think again. If you think you still know the rules, you don't. Because 12 brand new mandates are now in motion, some protecting your rights, others quietly erasing them. They affect permits, background checks, training, and even how soon you can defend your own home. And the most dangerous part? Most gun owners haven't even heard about them yet. So before the next trip to the range or the next time you carry, stop everything. What you don't know now could cost you later. Stay alert. Because today, we're breaking down the 12 new gun rules every American owner must understand one by one before the next enforcement wave begins. Hit subscribe, stay ready, and let's break it all down. When the Supreme Court handed down its 6-3 decision, it didn't just close a case, it opened a storm. Overnight, the entire landscape of firearm law in America changed. Hidden inside the legal language are 12 new rules that reshape everything from how you apply for a carry permit to how the federal system tracks background checks. For every gun owner who thought they understood the boundaries, this ruling is a hard reset. What used to be a matter of state discretion has become a question of constitutional clarity. The message from the bench is unmistakable. The Second Amendment now stands shoulder to shoulder with the First. The first major shift comes in how permits are issued. States that once used a may-issue system, where officials could deny a carry license based on personal judgment, are suddenly on unstable ground. California, New York, and New Jersey can no longer hide behind subjective discretion. The ruling insists on a simple truth. Rights are not favors. If you meet objective requirements, the state cannot ask you to prove your need to defend yourself. For millions of Americans, that means the end of waiting months or years for approval. The law now favors immediate access, not bureaucratic permission. But the ruling goes deeper. It challenges the very timelines that states use to delay. In the past, agencies could stretch processing times to 6 or even 12 months. Now courts are calling those delays unconstitutional. The right to carry, they argue, is immediate, like speech or religion. You don't wait to express an opinion, and you shouldn't wait to exercise a constitutional right. Lawsuits are already surfacing in Illinois and Massachusetts, and fast-track injunctions could force states to move quickly or risk being struck down entirely. Another battlefield opens around mandatory training. For years, gun control advocates used training mandates as quiet barriers, hundreds of dollars in fees, weeks of classes, endless paperwork. The court has drawn a new line. If a regulation has no roots in historical tradition, it's suspect. That doesn't mean training is bad. It means training cannot be used to block access. A law that demands 40 hours in the classroom may sound responsible, but if it effectively bars working citizens from qualifying, it crosses the line. Expect challenges in Maryland and Connecticut, where training costs and wait times have reached extreme levels. The decision also aims its spotlight on background checks. While the court did not eliminate them, it emphasized that they must be fast, fair, and free of political delay. A background check is supposed to confirm eligibility, not serve as a slow-motion denial. If the system takes weeks, or if errors in the national database hold up lawful purchases, that delay can now be seen as a violation of the right itself. Federal waiting periods beyond 3 business days are being reviewed. In states like California and Washington, where extra cooling-off periods were common, those laws may not survive constitutional scrutiny. The principle is clear. The burden of proof has shifted. The citizen no longer must prove innocence. The system must prove ineligibility, quickly and conclusively. Behind the headlines, the tension between federal and state power has never been sharper. States have long claimed the right to regulate firearms within their borders, but this decision reasserts federal supremacy when constitutional rights are at stake. A state cannot redefine the Second Amendment to suit its politics. The court's language is firm. Rights do not stop at a state line. If a rule in New York violates the same principle protected in Texas, the courts will step in. The ripple effect is already visible. Governors are ordering emergency legal reviews. Legislators are rewriting bills mid-session, and advocacy groups on both sides are preparing for a flood of new cases. One of the most dramatic consequences of this ruling is the rebirth of the Bruin precedent from 2022. Back then, the court required governments to justify any firearm regulation by pointing to historical analogs, real examples from the nation's founding era. This new decision cements that test as law. Any rule without roots in history stands on borrowed time. Judges must now evaluate gun restrictions the way they evaluate speech restrictions, through strict scrutiny. That standard makes modern innovations like universal background checks or red flag delays far harder to defend. What once looked like a safety measure may now appear as a direct infringement. For ordinary citizens, this ruling isn't just legal noise, it's practical reality. It means that what was acceptable last month might now be unconstitutional.